gallery view. I get pulled up on that all the time.
Okay, I think it says we're streaming live on Facebook.
Live. Welcome
so.
to the business of property, everyone. Property Development Australia. Hope we're doing well and staying sane in the current environment. We have Richie Muir from LawLab today. Richie is going to be talking and sharing his sort of knowledge around options. And Richie, we have a lot of people in the community here that are always keen on finding out a little bit more about options. So it's great that you're here. Thank you very much for taking time out of your evening.
No worries. Thank you, Cheryl. Thanks for having me.
Nice. I'm going to give a little bit of a blurb about Richie. He's a solicitor and legal director at LawLab, a leading national team of lawyers and conveyancers. LawLab, if you don't already know, is Australia's most popular national conveyancing law firm with a service designed to make life easier for developers, buyers and sellers to complete property deals smarter, simpler and more securely. And that is because you have a special sort of software interaction that you use. That
I mean, we're a mix of a human and tech business. Our tech is a platform called Rundl, and that's how we deliver our service digitally. So it's a collaborative platform, cloud-based, and we would invite a developer, project marketers, agents into that Rundl, or if we're acting for a buyer, we might invite the broker and agent as well.
Okay, so it's a real sort of, like you said, project management tool where everyone can interact in the one spot, as opposed to 200 emails in your inbox. Excellent. So, I mean, we've used obviously your services before, and we've been really, really impressed with that whole platform and the ease of it, and how you've got documents and everything in one place. So what we're going to be talking about is about options, and we've got a few things, a few questions we want to go through, and what I'll just click on to sort of Facebook as well. More often than not, people will be asking questions, and so in between I'll start it off and facilitate any questions there, but if anything comes up, I'll definitely sort of give a little bit of word.
Sounds great. Yeah.
This person's asked or made a comment. So let's start off. What is an option agreement?
Listen, options. An option agreement is essentially an agreement between parties where one party grants the other party the right, but not the obligation, to enter into a contract of sale to buy a property. And they can exercise that within a certain time frame. So there's usually a few types of options. There's a call option, and that's where the seller grants the buyer the call option, the right to call that option and enter into a contract of sale, and they can do that within a certain time period, and essentially walk away from that deal if it doesn't stack up. On the flip side, there's a put option, where the buyer grants a put option to the seller, and the seller can then force the sale of the property to the buyer. Put options don't exist a lot by themselves, but together, a put and call option can be quite common. So when entering into a put and call option, because I should say a put option is only exercisable by the seller usually once the call option period has expired. So if you've got a put and call option arrangement, and the buyer or the grantee doesn't exercise their option, then the seller can exercise the put option.
So is it quite similar then to a contract of sale?
Well, a contract of sale is usually attached to the option agreement. So you agree the terms in advance. So if we were entering into an option agreement now, we would need a contract of sale attached to the option agreement. So you agree on the price, you agree on the deposit, you agree on the settlement terms and settlement period, but the contract isn't signed at that stage. It's not entered into. You enter into the option, so it's just the right to enter into that contract at a later date.
Okay, so the put is to, like you said, almost put the buyer in the situation where they have to enter into the contract.
Yeah. A way of thinking about a put and call option is it's kind of like an unconditional contract.
Yeah.
You can still have some conditions precedent within that, but once those conditions are satisfied, it's kind of like an unconditional contract.
Okay. Oh, sorry. Go ahead.
I was going to say, except of course if the seller decided not to exercise that put option, which would only happen if circumstances changed.
Yeah. So effectively, call option allows the purchaser, the grantee, the option of basically walking away if the deal doesn't.
That's right. If it's just a call option, that's right.
Yeah. So why are they so widely used and so, I guess, for want of a better word, powerful?
Yeah, well, they're a very useful tool, and used in different scenarios. One example is if you wanted to secure the land, have the right to control that land for a certain period, you might want to do that because you're getting a development approval. So that can take some time, and by entering into an option agreement, you can defer your stamp duty liability to a later date, as opposed to a contract where it can be much earlier. So that's one example. There might be other examples where you want to flip the property, flip the option. So you might do some initial development approval and then sell it, on sell it essentially for an uplift, or marketers and builders might want to use it, so that they get the exclusive right to market that property for a certain time, and then obviously nominate the ultimate buyer after they've constructed the house and the land. From a seller's point of view, they might want to use an option to defer their CGT liability as well. So a CGT, capital gains tax liability, usually is triggered when entering into a contract. But of course, if you've got an option, that won't happen until the option is exercised and the contract is entered into. So it defers that capital gains tax liability.
Okay.
To another tax year.
Yeah. So there is benefit for, very often people sort of think that it's only beneficial for the purchaser or the grantee, when in fact it is also beneficial for the owner vendor.
That's right, yeah. And when you're negotiating an option, some things to think about, wearing the seller's hat when you're trying to sort of get them to enter into an option agreement, is that it can be a win-win for them. If often options are agreed at a price that are often higher than market value and current market value. But even if they're not, you can say to an owner, well, I'm spending a lot of money with this development approval. So, even if I don't go ahead and buy the property, exercise the option and buy the property, the land value has increased because I've got that development approval on the land. Development approvals run with the land. So, that improves the value of the land for the seller, and they can go on and sell it to someone else at a later date for that.
Okay, right. And so what are I guess apart from CGT and deferring that, what are the other benefits for a seller? Because I think we often find those in the community saying, it's really hard to get people to accept an option because it's something they're not familiar with. What are some tips to be able to say, hey, this is actually beneficial for you as well?
Yeah, you need to find motivated sellers. So, find out why they need to sell, or those who don't necessarily want to sell straight away, but they might have some time up their sleeve. But one of the things, of course, is getting the option fee right. So what a seller's doing is essentially, taking the property off the market for the option period, which could be 3, 6, 12 months or even longer. And they're losing the opportunity to sell that property to someone else. So, they would expect to be compensated for that. And people often ask, well, what's an appropriate option fee for that? And you need to balance that with the respective, bargaining positions of the parties. So, can the seller wait that long? Are they in desperate need of cash? Is an option fee $5,000 or $10,000 going to, get them through a difficult period, or are they expecting a lot more than that? And of course, other things to consider with the option fee is, well, duty implications. So in Queensland, for example, you'll pay duty on the option fee.
Yeah.
So in Queensland, you'd want to keep the option fee as low as possible from a buyer's point of view.
And the option fee has to be at least a certain amount?
Well, if it's an option agreement, there needs to be consideration for the option. So it can be as small as $1. But one thing to look out for is that it actually needs to be paid if it's an agreement. So for the agreement to be enforceable, that option fee needs to be paid to the seller. And if the put option, likewise, the seller needs to pay that put option fee.
I've got a question here. As a seller, should you or can you ask for a personal guarantee? I.e., why would you agree to any contract otherwise with a shell company? So I guess he's referring to an SPV.
Yeah, it's a good question. It will come down to whether it's a call option or a put option. As I said before, a call option, the buyer can walk away at any time. So what do you want them to guarantee? If they're guaranteeing a future payment that they've agreed to, perhaps you've agreed to a security deposit being paid after due diligence or something like that, and it turns out they just don't pay it, then as a seller you would want a personal guarantee to secure something like that, particularly if it's a non-refundable fee. And if it's a put and call option, then absolutely you'd want, as a seller, you would want to get a personal guarantee from a director or directors of the corporate entity, corporate buyer. But of course, on the flip side of that, the buyers want to reduce risk as much as possible. So, they may not offer that personal guarantee, particularly if they're sophisticated, developers. They'll want to manage their risk. And so it comes down to bargaining and negotiation. Would the buyer offer perhaps a larger, non-refundable fee rather than giving a personal guarantee?
Sure.
So you can negotiate some of these terms. So
it's really flexible. I mean, options are.
Very, very flexible. There are some sort of key terms within each option agreement, but one size doesn't fit all, and you really need to draft the terms that are appropriate for the situation.
Okay, excellent. So let's go back a little bit and talk about option 101. What are the key elements of a well-formed option agreement?
Yeah, starting with the basics. I mean, you need to obviously get the parties right. So the owner of the property, and you could check that by doing a title search, and then as the buyer, you want to make sure you got the appropriate entity as well. So making sure the parties are right, and then obviously making sure that the property is identified. And these sound very basic things, but not everyone gets them right. So identifying the property, and then you get to things like obviously the option fee. So that needs to be agreed to. There's the purchase price of the I guess what they call the strike price. The price that the contract will ultimately be needs to be agreed at that time as well. So you've got the option fee and you've got the purchase price. Because when you exercise the option, the contract is formed with that purchase price.
Sure.
So yeah, the option fee, as I said, that's negotiable. From a buyer or grantee's point of view, you want that as low as possible if you can. And from a seller's point of view, they'd want to be compensated for taking that property off the market for the term of the option.
Okay. And so once you get to exercising the option, does settlement happen on the same day of exercise, or do we have then you sort of enter into a settlement, enter into a contract and then settle?
So yeah, so there's the option period, and then there's a settlement period. So the settlement period for the contract is similar to a usual contract settlement period. So, and that varies between states. So in Queensland it might be 30 days. In New South Wales might be 42, and in Victoria, anything between 30 and 60. But of course, this is all negotiable, and usually by the time that the buyer, has got to the stage of exercising the option, you would have thought that if they're going ahead with purchasing the property, that all their finances are in order, so they might be prepared to have an earlier settlement. And that might be a negotiation tool as well with the seller saying, okay, well, once we're ready to go with the option, we'll be able to settle this within 14 days.
Okay.
But of course, on the flip side, a seller, because the buyer can exercise a call option at any point within the option period, which could be a year or so, the seller may not be ready to, if they're living there, to move out the property, within the space of 14 days. So it comes down to negotiating what's an appropriate time in the circumstances.
And I think that, and you may have touched on it already, that the option period doesn't necessarily mean that that is your definite period of the transaction or the agreement. You can actually exercise a lot earlier if you so
Absolutely,
wish.
yeah. So there's in New South Wales, you can't exercise within the first 42 days of the option agreement. But yeah, if you had a 1-year option term, you as a buyer, you could exercise it, immediately after that 42 days in New South Wales, and at any point in other states. Just on that, often in particularly put and call option agreements, because a buyer is essentially entering into an unconditional type arrangement, usually you'll find due diligence clauses and development approval clauses within the option agreement as well. So, there's the option term of, say, a year in our example, but there might be an initial due diligence period of 30 to 60 days. So the buyer can take some initial investigations, the property, see if the deal stacks up. And then if they do satisfy due diligence, then they might need another 3, 6, 12 months to complete development approval, depending on the particular project. So of course, if they can't satisfy those conditions, if the deal doesn't stack up, or if they can't get DA, then obviously they can terminate the option agreement under those terms.
So what's a good way to secure a deal but still have it under due diligence? Should we enter into a call option from the very beginning, or is there some other way to at least secure it?
Well, I mean, from a buyer and grantee's point of view, you always try and get a call option agreement. You wouldn't agree to a put and call option agreement if you could get away with it. So a call option agreement is ideal. And if you've got a call option agreement, because you can walk away at any stage, you don't necessarily need a due diligence clause in that option agreement, unless you want to use that as a condition precedent to paying a further deposit. So you might have a due diligence clause, and then after due diligence satisfied, you might pay a further security deposit, which ends up going towards the purchase price. So you can walk as a call option. You can walk away at any point, so you don't necessarily need those. But if the seller does want to lock you in, then then you really need those clauses in the agreement to give you an out if the deal doesn't stack up. Okay.
And so how do you, what's the mechanics around exercising the option?
Yeah, so you've obviously got the option period. What you usually find in option agreements is a clause setting out specifically what needs to happen to exercise the option. And these can be quite prescriptive, and if they you need to follow them in accordance with the option agreement. Otherwise, the option may not be exercised properly and may not be enforceable. So ideally, when you're drafting option agreements, you try and pull back on the prescriptions for exercising the option. Usually, it will say you need to give notice to the seller that you're exercising the option and sign the contract that's attached to the option and provide that notice. Now, that notice needs to be in writing, and ideally you'd want to be sending that by email, particularly in the current climate. But you often find older option agreement templates will require that to be sent by fax or posted or delivered. So ideally you want to make sure there's an email clause. And in some option agreements, you'll also find a annex to the option agreement. There will be a form of notice of exercise of the option. So you'll need to complete that, sign that, attach the contract, and any other disclosure statements or things like that that are attached to the contract. Sign those together with, in some states, you might need to waive the cooling off as well, and then send that to the seller's solicitor.
Okay. So make sure that you follow all your steps, and that it's also documented as to how you need to exercise it. I'm just going to say hello. Sorry.
I was just going to add in there. If you've engaged a solicitor to prepare the option agreement, use them again to exercise the option.
Yes.
Because if it's not done properly or something's missed, and it needs to go to the person to the notice of address of service within the option agreement. If it's not sent to that person, then you could have issues with enforceability.
Has there ever been that situation where someone hasn't used the same solicitor?
Oh, I don't know about that, but there've been issues where the notice of exercise the option has been held to be invalid, because of course there's a time period, right? So another example is if you had to post it, and you only realise that you're getting close to running out of the option period. The postal service can take several days, so it might be too late to exercise the option if you haven't planned for that in advance.
Yeah. So just use email. So much easier.
as long as the email is a form of service in the contract, in the option agreement.
Yeah. Okay. Excellent. I did have a few questions here, and I don't know where Daniel. I saw a question pop up, and I think it was asking about duty, which we'll talk about very soon. Hi, Michael, Joseph, Sean. Sean Hayes has probably done about, I don't know, 50 option deals over the last few years, so he could have a bit of a chat with you too. All right, I think we'll move on to sort of a few more questions around. I know very many people enter into options for the mere fact that they want to be able to flip a deal. How does that happen, and what's a good way to structure that?
Yeah, that's another key term of the option agreement. So the right to on-sell, and it can be in a few different formats, but essentially you need a nomination clause within the option agreement. So the right to nominate another buyer, and once again, often there is an annexure to the option agreement in a particular format that you need to complete, sign, and send to the seller's solicitor when you're nominating that buyer, and often that party will need to essentially agree to be bound by the original option agreement. So there's covenants within that. So yeah, there's another formal process of nominating a buyer, and you need to make sure that that's followed correctly as well. That's a key term of the option agreement. So the other form of nominating a third-party buyer is often where perhaps a marketer or a builder has entered into an option agreement, and there should be what they call a third-party contract clause. So the ability, so rather than just nominating this buyer to jump in the shoes of the original buyer, there's a third-party contract clause where the ultimate buyer enters into a contract with the owner, with the seller, and it could be for a higher price than what the original buyer and the seller have agreed to, and the difference in those prices is what the original buyer gets.
Yeah, and so is that fairly transparent in that process, or?
Well, it needs to be set out in the option agreement from the start.
Yeah.
It's not necessarily transparent to the ultimate buyer. So this might happen a lot with builders. So, you know, there might be a house land package that the builder markets to an ultimate buyer, and the ultimate buyer will enter into contract with usually the land developer, but they may not be aware that the builder has an option agreement with the developer.
Okay. So all the ultimate buyer sees is the end price, and they are transacting with the original.
Yeah, in that arrangement. Yeah.
Okay. And so my next question is around nominating and novations. What's the difference between a novation clause and a nomination clause? Yeah,
I mean, nomination, I think for the purposes of option agreements, probably it's best not to get too caught up in that. They essentially have the same effect. The slight difference is whether one party is bound by all the obligations in the original agreement, or just has the rights to settle. So I think for the purpose of this we won't get into too much detail on that, because the duty implications are very similar. So we can talk about the duty implications of nominating or transferring or novation.
Yeah, so that's a good segue into that, because that's the other thing. You want to be able to on-sell your option for a bit of a higher price. Where does the duty kick in, and how can someone look at calculating what that might be?
Yeah, so this is one of the sort of the hot topics within option arrangements, and the rules differ between the states. Obviously, each state has their own stamp duty laws, and so I guess we can talk about the main three states, the eastern states. So Queensland, New South Wales, and Victoria. Starting where I am in Queensland. As I said, there's duty on the option fee, or the value of the option, and there's essentially, if you were just to do a nomination without any uplift, so you won't get an on-sale profit or uplift from the nomination, then there's usually no duty on that. Obviously, the ultimate buyer will pay duty on the purchase price. But where there is an uplift, so we've nominated someone and there's been uplift, then they'll pay duty on the value of that uplift. So you got to remember, in Queensland as well, both parties are responsible for duty under the Act. So you need to make sure that in any nomination deed, a nomination agreement, where you're doing this for uplift, you need to make it clear who's responsible for the duty. So that can be the original buyer who's nominating the ultimate buyer, or it could be the ultimate buyer. You need to make sure in the nomination deed who's responsible for that extra duty. Okay,
so there is double duty potentially.
There's the extra duty, I would say, in Queensland, extra duty rather than double duty.
Okay.
There's the extra duty on the nomination fee. So if you've bought something for $1 million, and and you've flicked it on for $200,000 profit or uplift, then there'll be extra duty on the $200,000. Okay.
And is there a simple way to calculate what that duty might be?
Well, I think as a rule of thumb, if you go, and this is a national rule of thumb, if you go between 4 and 5% of the price, that'll give you a fair estimate of the duty. But of course, there are stamp duty calculators on each of the state revenue websites.
Okay, so if you say that example of you purchased exercise price is $1 million and you've got 200 grand uplift, what would that duty look like in that scenario?
My maths isn't great, but yeah, around. So if you say 4 or 5% of that 200,000 on top of the
200,000.
Yeah,
okay.
Yeah.
All right.
And the ultimate buyer still pays the duty on the $1 million as well, obviously at the end. Now that obviously position changes between the states. So moving on to New South Wales next, there's no duty on the option fee. If there's no uplift, there's no additional duty. The ultimate buyer pays duty as normal. Now, if there's valuable consideration, if there is uplift, then there's 2 lots of extra duty, potentially. If in a call option arrangement, or in either arrangement, a call option or put and call option, there's nominee duty. So you're paying the extra duty, like you would in the Queensland example. And that's brought forward to the point of nomination, not when the option's exercised.
Okay.
If it's a put and call option, you have what's a bit of a misnomer, but it's called a call option assignment duty. So, yeah, a put and call option where there's valuable consideration, so where there's uplift. The original buyer or the grantee who's transferring that option, they will pay duty on the value of the property. Mm-hmm. So that's the double duty, and of course the ultimate buyer will then pay duty as normal.
Okay, right.
Yeah, so that's something to and these relatively recent laws as well. So that's something to be aware of in New South Wales.
Because we used to be able in New South Wales, and I say we because I'm in New South Wales, we used to be able to on-sell options and not have to pay any duty in the good old days.
Good old days, yeah. Now the state governments want their slice of the action. Yeah. And Victoria's arguably, a worse position for that.
Okay, so let's move on to Victoria then. What's the situation there?
Once again, no duty on the option fee itself. Now, if there was a nomination, assignment, transfer of the option, and on-sell of the option without any uplift, but nothing had changed, if you hadn't done anything, there'd be no duty. But if there had been land development between the time of entering into the option and exercising the option, then you would be paying double duty on that. So land development. So what does that mean? That can mean taking relatively small steps actually. So applying for development permits or building permits, preparing a plan of subdivision, appointing consultants. So any of that kind of stuff is considered land development. And so if you got an option and started some initial DA work, and then nominated someone else, even though you didn't get an uplift for that, you would still have to pay duty on that arrangement. Okay.
Right.
And then the other scenario is, of course, if there's been, irrespective of whether there's been land development, if there is an uplift fee, you'll also pay double duty in Victoria. So there's the duty payable by the original buyer and duty payable by the ultimate buyer in that option scenario.
Okay, so if there's no change in the value, but you've done some sort of development, whether it's putting in planning or whichever, how do they calculate then is there a duty for that? I guess there's no difference there, but it's just double duty on either side.
Yeah. So so on $1 million property, that's around about 5.5% in Victoria.
Mm-hmm. Mm-hmm. And so the ultimate buyer's got to pay that, and the original
buyer, yeah.
Wow.
Yep.
Good to know.
Yeah, so it can be very, very expensive. Another thing to point out in Victoria, when I mentioned the uplift or additional consideration, there's also what's called a parallel agreement. So if you tried to this particularly affects I guess builders and sort of house land packages and builders options. So if they were to take an option over land, a builder would take an option over land, and then nominate the ultimate buyer. If they entered into a building contract within 12 months, that would be considered additional consideration, and double duty would apply.
Okay, right. So you've got to be pretty careful in Victoria how you're entering into your option.
Yeah. And that one, it's not just builders as well. It could be associates of builders. So you might have marketing groups, and if they're getting a benefit through these parallel agreements, then they can be hit up for double duty.
Okay, good to know. The other, Daniel, there's a question. What's the rule in Victoria? Sorry, give me a moment while what's the rules around Victoria with on selling an option? I think we just covered that one. Joseph? Yeah.
Yeah, and the two key things to consider when on selling: has land development occurred from after I entered into the option, and is there any additional consideration? So if either of those apply, there's going to be double duty.
And then there was the other question before that was posted on the event page itself. I don't know if we've already addressed that, regarding some changes that David Andrews enforced recently.
So that I guess these are the relatively new laws about double duty. There's also a thing called economic entitlement as well, which is another type of additional duty. And that's not so much options, but that's the government's attempt to sort of grab a bunch of extra duty from particularly joint ventures and development agreements where there's economic benefit from entering into these arrangements with landowners.
Right. Okay.
And that applies to any property over $1 million.
Yeah, where previously sort of someone might enter into a development management agreement and it really being structured like a joint venture.
Yeah. So so slightly off topic from options, but there's been quite a few stamp duty changes.
Okay, great. So, and this is one of the questions, probably a top 10 in the community, is there a standard option agreement that people can use?
Yeah, I mean, as I said before, there's always some key terms to consider that will always go into option agreements. And if I guess if you're doing a rinse and repeat kind of project, and you've got a good option agreement drawn up initially, you could probably reuse that each time. But if you're doing different, but you should really get a lawyer to look over that, particularly if you're doing different kinds of projects. And as I said, they should really be prepared. It's not. I mean, there's a bunch of things that need to be considered before drafting the option agreement. So you could have a great option agreement template, but it may be missing things, or there's things you haven't considered. And that will depend on the circumstances.
Yeah, because every deal is so different in every way. You just got to make sure that particular option covers that. We've got a few questions here. How much does it cost to set up an option?
Yeah, listen, I mean, my pricing starts from $891 for an option agreement, and that will cover most scenarios. But of course, if there's protracted negotiation between the parties, then obviously that can cost extra.
Okay. What do we do? What's the rules? Oh, we got the same question with Victoria. Oh, good. Let me just, sorry, we'll watch the replay. Yes, Daniel, watch the replay. If you missed bits, it's a good thing about Facebook Lives. It does get recorded. I think we've exhausted some of the main questions already, Richie.
Okay.
If we have any others, anyone's got questions, comments. Oh, yes, Joseph. What if you sign the option under a company and then on sell the company? Oh, yes, good question. I know we used to deal with that in New South Wales. What are the stamp duty implications there? Is it possible to purchase the company that's entered into the option and avoid stamp duty?
Possibly, but obviously you need to think about the company that you purchase, what stamp duty liability they have, but also what other liabilities they have. You might not know much about that company, but then you need to also consider things like landholder duty, and it's called various things between the states, but the principle is if a company owns land holdings over a certain threshold, then they have to pay duty on that. And if there's a change in shareholders, so if you're buying that company, then you could be hit for duty as well. So that's something else to think about.
Yeah, I do know in New South Wales that was something that quite a few developers used to do, was to take over if it was a shelf company. But obviously, like you said, there's the risk of not knowing the history of the company and what sort of other liabilities it might have.
Exactly. Yeah.
Okay. Good. All righty. Any more questions? I'm sure they'll pop up. Please, Richie, if you could have a look at the particular post as well. Often the comments just pop up the next few days. What's the best way for people to get in contact with you?
Yeah, well, I mean, I can share my email address really. So pop me an email. There's details as well on our website at lawlab.com.au.
If you haven't noticed the branding in the back, Law Lab, that way, .com.au. Excellent. We've been really happy. Like I said, we're doing some transactions at the moment and been really happy with the way that it's sort of panned out. Also to note that you were involved with the recent settlement for Bricklet. I think Darren was on this, so that's exciting.
Very, very exciting. Yeah, it was. I think they've called it a world first. Certainly, I've never heard of anything like it, where they've the fractional property investing, but all the investors are on title. So I think we ended up with about 26 owners on title, all tenants in common.
That's great.
Yeah, it was a very interesting transaction.
Yeah, good. So anyone that's looking at Bricklet for funding, obviously Richie is across that, which not a lot of people are across. So that's really good to know.
Yeah. Would love to help out with anyone interested in that as well.
Excellent. Well, thank you. That was very, very informative. Like I said, options are probably one of the top topics that the community ask about all the time. So all we need to do now is refer to the video instead of going through. But we'll add, if you can send me your email and I'll pop it onto the comments.
That's fine. Yeah. And any questions on Facebook, I'll jump on when I can and answer those too.
Awesome. Thank you so much.
No worries.
Stay safe, stay sane as well with isolation and little children. I know what it's like.
Yeah. Very challenging. Yeah.
It is. It's fun. Lots of fun. Yes. Either way, take care, everyone. Thank you, everyone, for tuning in. And we'll see you all next week. That's Richie. Ciao.
Thanks, Cheryl. See ya.
Bye.
Bye.